Good morning, everyone. Welcome to Assembly Judiciary. We'd like to welcome everyone here in Carson City, as well as those watching from Las Vegas, and anyone who may be watching online on the Legislative YouTube or through Nellis. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Considine. Assemblywoman Gallant. Assemblyman Gray. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman LaRue Hatch. Assemblywoman Marzola. Here. Assemblywoman Mosca. Here. Assemblywoman Newby. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Present. Assemblyman Urick. Here. Chair Miller.
Here. And please mark Assemblywoman LaRue Hatch present when she arrives. Just a few reminders, a few housekeeping issues. Again, please turn down any noise on your electrical devices. Also, for everyone viewing, we will have a public comment section at the end of the meeting, which everyone will have up to 2 minutes to make a comment based on something under the purview of this committee. Also, a reminder that anyone presenting, please make sure you have your exhibits in by 12 noon the day prior to your scheduled date. With that, today we have one presentation and 2 bill hearings, and we will be taking the agenda in the order that it is currently printed. First, we have a presentation of the overview of the Office of Attorney General. And I believe our Attorney General Ford is presenting. That's not what my notes say. I have Chief of Staff. Who's presenting? Yes, please, Attorney General.
Thank you, Madam Chair. Aaron Ford for the record. My Chief of Staff, Teresa Benitez Thompson, is caught on the icy bridge at Galena and headed over. She'll be here very soon. So I am presenting with her, but she knows how to work the computer and I don't. So if you wouldn't mind trailing this maybe until after a couple of the bills, after one of the bills you hear, that'd be great. Unless you want me to try to work it.
That's up to you, Attorney General.
Okay, I have a friend here. I phoned a friend. Thank you.
Are you sure, or do you want to wait?
Ma'am.
Okay. All right. Thank you.
Oh, there she is.
So right on the nick of time.
Okay.
So we'll just give you all a few minutes to get settled. So in a few minutes, we're going to have a presentation of the overview of the Office of the Attorney General by the Chief of Staff for the Office of Attorney General, Teresa Benitez Thompson. I know that some people are familiar with her as well, and it's good to welcome you back into the Assembly Judiciary this morning. Good to see you. So take a few minutes because we understand you may need a few minutes, and then we'll proceed when you are ready. Everyone will sit at ease for a few minutes.
Good morning, Assembly Committee on the Judiciary. So good to see all of you today. Teresa Benitez Thompson, Chief of Staff to Attorney General Ford. Apologies for coming in late. I rode in on a sled. It felt like most of the way in from Northern Nevada. We appreciate this and have the pleasure to introduce Attorney General Ford, and he's going to walk you through the breadth and depth of all the things that this amazing office covers.
Thank you so much. May I proceed? Madam Chair, great to see you this morning. Vice Chair, members of the committee, my name is Aaron Ford, and I am your Attorney General. Delighted to be back in the building today. Today I have the opportunity to provide an overview of the Office of Attorney General. My office consists of nearly 350 dedicated and hardworking individuals committed to enforcing Nevada law and upholding justice for the protection and benefit of our residents. Every Attorney General brings their own perspective as to how to protect and improve the lives of Nevadans. The overarching theme I've used to set the intention of our work is a theme that you've heard me say time and time again, and that is our job is justice. To guide my decision-making, I have framed my administration by a set of policy priorities. These priorities do not override our statutory obligations, but rather they serve as a lens through which we view our work. I refer to these priorities as the 5 C's: constitutional rights, criminal justice and reform, consumer protection, client service, and community engagement. Each of these C's serves as a moral compass to guide the ways in which our office can serve Nevadans. As the chief law enforcement officer in the state, the Attorney General's office represents the people of Nevada. We are the people's lawyer before state and federal trial and appellate courts in criminal and civil matters. We serve as legal counsel to state officers, state departments, and most state boards and commissions. And we work with our local, state, and federal law enforcement partners to protect the public. In addition to my written testimony, I have provided committee staff with an agency organizational chart. I also invite you to read a copy of the agency's biennial report, which can be found at nv.ag.gov. While that report goes into significantly greater detail, I'd like to highlight a few key accomplishments of the Office of Attorney General over the last 2 years of my administration. We have saved over $1.33 billion, with a B, billion taxpayer dollars by vigorously defending the state against tort claims. This number does not include litigation on other causes of actions. We have entered into settlements with opioid manufacturers, distributors, and marketers, bringing hundreds of millions of dollars into the state to help the state combat the opioid crisis. In fact, today you will hear about another settlement bringing in nearly $30 million additional dollars to help fight this opioid crisis. We investigated and prosecuted those who seek to harm Nevadans, including murderers, some of whom committed their crimes in our prison system, abusers, and scammers. We provided robust constituent services to Nevadans asking assistance, receiving over 18,454 complaints and 39,069 inquiries in the last reporting period. Our office is composed of several divisions with specific assignments related to the Attorney General's statutory responsibilities and the administration of the office. I'd like to now turn to each of those divisions in more detail. Several divisions are dedicated to one of the most sacred responsibilities in the office, and that is seeking justice for victims of crime and protecting vulnerable Nevadans. Our Criminal Prosecution Division, run by Chief Alyssa Engler. This division prosecutes financial fraud, including scams, insurance fraud, workers' compensation fraud, securities fraud, mortgage fraud. She also prosecutes sex trafficking, cybercrimes, public integrity cases, and crimes that occur in the Department of Corrections facilities. In the past 2 years, this division has charged several murder cases, including killings in Nevada's prisons. We are continuing the prosecution of Charles Sullivan. If you are up north, you may recognize this as a cold case in regard to a 1979 murder of a Reno woman, though the trial was delayed due to the pandemic and other evidentiary issues. We've also prosecuted hundreds of cases from child sex trafficking to scams and frauds to animal abuse. In state fiscal years 2021 and 22, the Workers' Compensation and Insurance Fraud Unit filed 308 prosecutions and had over $1.2 million in restitution awarded to the state. As a prosecuting agency, it is particularly important to me that when it comes to the criminal justice system and criminal justice reform, we do not just talk the talk, we walk the walk. Our office adopted new internal policies to ensure that our charging decisions and bail requests are appropriate and ethical, and we incorporate the victim's wishes whenever practical. And we seek justice, not vengeance. Moving on to our post-conviction division, I happen to be accompanied by our chief, Heather Proctor, to my left. She will be presenting on the bill a little later. And that division handles petitions for habeas corpus in state and federal courts. This division also is responsible for representing the state in death penalty appeals. In the past biennium, the division opened up 185 federal habeas cases and 381 state habeas cases. This division is also responsible for implementing the law passed by this body to compensate those Nevadans wrongly convicted of crimes that they did not commit. To her credit, I'm going off script for a second, Chief Proctor took that job. I asked her to, and she took it, and has presented to us probably a dozen or so wrongfully convicted individuals that we have been able to compensate. We talk about justice in our office, and I say justice doesn't always manifest itself in an arrest and a conviction. Sometimes it manifests itself in an exoneration and compensation. And we've been able to demonstrate justice through the work that Heather has been able to accomplish with her division. So I want to thank her publicly for that work. Moving on to Medicaid fraud, our Medicaid fraud control division, our chief is Andrew Schulke. The Medicaid Fraud Control Unit investigates and prosecutes fraud by healthcare providers in the Nevada Medicaid program. For the past biennium, the OAG's Medicaid Fraud Control Unit opened up 186 investigations, successfully prosecuting 34 criminal cases involving fraudulent activities by companies scamming the Medicaid system and recovered $10.3 million in the process. The MFCU also reviews reports of abuse of criminal neglect of patients in facilities that use Medicaid. This unit focused on community engagement, partnering with medical schools to train students on how to identify signs of elder abuse and neglect. Very proud of them in that work as well. The next division I'd like to touch on is our Consumer Protection Division. It has its own C. The Consumer Protection Division, our chief there is Ernest Figueroa, he's actually our consumer advocate. The chief of Consumer Protection is Mark Kruger. And that division diligently works to protect Nevada consumers from economic harm. That division has 4 primary areas of focus: advocacy for ratepayers before Public Utilities Commission and Federal Energy Regulatory Commission to ensure ratepayers receive reliable utility service at a reasonable cost. That's predominantly Ernest Figueroa's responsibility. This division also protects consumers through enforcement of the Nevada Deceptive Trade Practices Act. It also prevents unfair marketing through enforcement of our Unfair Trade Practices Act and federal antitrust laws. And it's responsible for the administration of the Home Again Nevada Homeowner Relief Program. In the past 2 years, this division is responsible for bringing tens of millions of dollars to the state as a result of settlements with companies that violated Nevada's consumer rights, such as consumer data breaches. Of note, we negotiated a settlement in the T-Mobile merger to guarantee that every T-Mobile job in Nevada would stay in Nevada, and employees' bargaining rights would be protected. Additionally, T-Mobile is offering and will continue to offer a low-cost plan for Nevada's consumers and build out coverage for rural internet service. The team is also responsible for responding to thousands of COVID-19 related complaints, such as price gouging, failure to issue refunds, illegal evictions, and scams. The BCP also represented ratepayers before the Public Utilities Commission, saving them from increased utilities costs, especially due to the fiscal impact of the pandemic. This includes litigating a general rate case before the Public Utilities Commission that resulted in a $120 million credit to the ratepayers in Southern Nevada. Consumer protection staff also helped Nevadans protect themselves from scams through community education and outreach programs. Just the week of Valentine's Day, I was on with AARP of Nevada talking about romance scams. These are the types of things we do from a community outreach perspective in the Consumer Protection Division. Moving on, I'd like to talk about our Investigations Division, which is helmed by Chief William Scott, a 29-year veteran of Las Vegas Metropolitan Police Department who has been with us for about 4 years now. The OAG investigators work directly with our prosecutors and local and federal law enforcement partners to investigate a wide array of criminal activities. Since 2020, the Investigative Division has completed almost 950 investigations and referred 440 cases for prosecution, arrested 188 subjects, and recovered 61 missing children. Additionally, the Attorney General's Office provides vital support to Nevada through the multi-jurisdictional task force, such as the IRS Financial Fraud Task Force, the Child Exploitation Task Force, the Healthcare Fraud Task Force relative to opioid-related matters, the Southern Nevada Human Trafficking Task Force, the Elder and Vulnerable Person Investigative Task Force, and the FBI's Joint Terrorism Task Force. The Investigations Division has also focused on engaging with the local community as well to better foster relationships and trust with people that we serve. Moving on to our next division, in the audience as well as someone you may hear from for another bill, Nicole Riley is our ombudsman for domestic violence. That's one of the biggest, I got goosebumps thinking about it, one of the biggest areas of our office here. Nevada holds the unacceptable distinction of being one of the worst states for domestic violence. The Domestic Violence Ombudsman serves as a liaison with all state and local partners on issues related to domestic violence, sexual assault, and human trafficking. The Ombudsman serves as a state-level coordinator with oversight of many programs and initiatives, including the statewide Committee on Domestic Violence and the Nevada VINE, which is a statewide automatic system that allows victims to receive timely, accurate information on the custody status of offenders. Moving on, one of the carryover programs that my predecessor created that I kept was the Office of Military Legal Assistance, initially introduced by then Attorney General Adam Laxalt. We have Special Assistant Attorney General Don Jensen, who oversees that particular division, and they provide pro bono legal advice for veterans and military families in civil matters. It's the first of its kind in AG offices around the nation. It's been actually replicated. We're very proud of this, and I was talking to the Ohio Attorney General in December, I believe it was, who's looking to now replicate this program there in Ohio as well. Since the program's launch in 2015, and with the assistance of our pro bono legal aid partners, the OMLA has helped over 3,650 service members and veterans. Even during the pandemic, the OMLA continued to operate virtually, particularly assisting military families facing evictions. I'd also like to talk about a few of the things that we do that representing our state. The OAG represents all constitutional officers and the state executive branch agencies, as well as many statutory boards and commissions. The attorneys within these divisions have a broad range of expertise, including the fields of state and local taxation, business law, regulatory law, election law, employment law, constitutional law, and civil litigation. It is in these divisions that my priority of client service is paramount, though staff often find ways to incorporate other priorities, such as the protection of constitutional rights. Moving to the gaming division in this particular arena, Chief Darlene Caruso helms that division. The staff of the gaming division advises the Nevada Gaming Commission, the State Gaming Control Board, the Nevada State Athletic Commission, and the Nevada Gaming Policy Committee. In addition to daily legal advice, staff also represent the board and commission at monthly public meetings. Litigation in this division includes disciplinary actions brought against gaming licensees, disputes regarding taxes and fees, hearings on the surrender of gaming licenses, and actions to add people to the list of excluded persons, the black box, the black list, I think is what it's called. Moving on to boards and open government, that's helmed by Chief Rosalie Bordelove. The Boards and Open Government Division provide counsel to all of the NRS Title 54 occupational licensing boards on administrative law and procedure. Also on administrative rulemaking, on the law of licensure, and the open meetings law. Deputies in the division attend meetings of all the boards and commissions, as well as serve as prosecutor and board counsel in disciplinary proceedings against licensees. Staff are also responsible for enforcing the open meeting law for all public bodies. Our Government and Natural Resources Division is overseen by Chief Greg Ott. That division serves clients, agencies, and officials responsible for providing core government infrastructure, such as the Controller, the Department of Administration, the Nevada Indian Commission, and PERS. The division also serves agencies responsible for managing and protecting the state's natural resources and environment, such as the Department of Conservation and Natural Resources, the Division of Environmental Protection, and the Department of Water Resources, as well as the Department of Nuclear Projects, as well as others. Attorneys in this division helped come to a settlement agreement with the U.S. Department of Energy to remove that plutonium shipment. You remember that secret plutonium shipment? We came to a settlement with the U.S. Department of Energy to get that removed after it was sent here without our consent. Chief Sharon Benson is our new chief of the Health and Human Services Division. Staff in that division serves as counsel to the Department of Health and Human Services and its many divisions. The OAG advises DHHS on some of the most critical matters to Nevadans, which includes services in its divisions of healthcare, finance, and policy, Medicaid, welfare and supportive services, health, mental health and developmental services, aging services, and the Division of Child and Family Services. As you can imagine, this team has been absolutely critical to the state's COVID-19 response. Moving on to the next division, personnel is run by Chief Cameron Vandenberg up here in our Reno office. And that division advises executive branch departments, divisions, and agencies on employment law, including administrative hearings regarding discipline of state employees, judicial review of administrative proceedings, resolution of grievances before the Employee Management Committee, and litigation in all state and federal courts regarding the employment relationship. Chief Randy Gilmer oversees our Public Safety Division. That division advises the Nevada Department of Corrections and provides representation in all inmate-related litigation, including property and constitutional claims. Staff in this division also participate in the Inmate Mediation Program, which is a unique program of alternative dispute resolution for inmates. Moving on to our Transportation Division, we'll have to correct this slide. Our Transportation Division is Lori Story, is our chief. The Transportation Division advises the Transportation Board on directors and many divisions of the Nevada Department of Transportation. Staff in this division provide counsel on many complex transportation matters, and attorneys in the division also represent the Department of Public Safety and its many divisions, including parole and probation, as well as the Department of Motor Vehicles. Chief David Pope oversees the Business and Taxation Division, which provides daily legal advice to the Department of Taxation and the and the Department of Business and Industry, as well as its 11 divisions, including the divisions of real estate, mortgage lending, insurance, financial institutions, the Taxi Cab Authority, Transportation Services Authority, the Labor Commission, Consumer Affairs, Housing, Industrial Relations, and OSHA. Attorneys in this division also enforce the Tobacco Master Settlement Agreement and its compliance program to prevent underage smoking. Staff also represents the newly created Cannabis Compliance Board, relatively newly created Cannabis Compliance Board, and prosecutes violations of cannabis licenses. We also have a Solicitor General and a complex litigation division in our office. Solicitor General Heidi Perry Stern oversees that division, and that division oversees all appeals before the Nevada Court of Appeals, the Nevada Supreme Court, and the Ninth Circuit Court of Appeals. It also houses the complex litigation division, a team of highly specialized and experienced attorneys who work with staff in all divisions of complex matters or cases that expose the state to great financial liability. Moving on to the administrative division, and I'm almost done, Madam Chair. We do a lot of work over here. The OAG is more than one of the largest law firms in the state. It also represents a constitutional office elected by the people of Nevada to serve our state. The OAG has a lean yet efficient staff who support the daily functioning of a large agency. The administrative division includes IT personnel, human resources staff, office managers, and legal secretaries dedicated to each legal division. The communications team manages a robust public outreach program to help Nevadans protect themselves from crime and respond to media inquiries. The Constituent Services Unit is responsible for attending to all complaints, concerns, and questions sent to the Office of Attorney General. From July 2020 to August of 2022, CSU staff processed more than 18,000 complaints and over 39,000 inquiries. I referenced that earlier. And we have about 4 people in that division. I want you to understand how small that is and how much work they've had to do. This does not include phone calls and walk-ins to the office. The Administration Division also houses the Chief Financial Officer, who oversees fiscal analysts, Tort Claims Administration, and the Grants Unit. The Grants Unit is currently administering 17 grants for a total of nearly $16 million. The Grants Unit manages several federal programs focusing on supporting victims of domestic violence and sexual assault, elder exploitation, and gang suppression. The Grants Unit has developed close relationships with local, state, and federal agencies, victim service providers, and others to administer grants across the state. Looking forward, it's clear that we as elected officials have a lot of work to do to build trust. Our nation and our state is divided. They are divided, and trust in our government is broken. some of our neighbors trust what they read on the internet more than the people that live in our communities and the people elected to represent them. I often say that as a representative of the government, there are three types of communities that we have to work with. One is the type that you see on Law and Order SVU, where Olivia Benson is testifying on the stand, and she's giving testimony, and everybody in the jury is nodding their head saying, yeah, she's telling the truth. And anybody who says something different, they're liars. That's one community that has the utmost level of trust in government, law enforcement. There's another kind of community that had that high level of trust, but it's diminished for some reason. Maybe it's because of something that happened to them or something they've seen vicariously happen to others. But it's a diminished level of trust. Then there's a third community, frankly, the kind that I came from when I grew up, that had little to no trust in government, let alone law enforcement. Because sometimes we wanted them to come when bad things were happening, but sometimes bad things happen when they came. And so in my job as the top law enforcement officer in the state, in this office as the people's lawyer, I view it as our responsibility to augment trust where it already exists, to restore it where it's been diminished, and to create it where it's never existed in the first place. And that's the work that we put in through our 5 C's and through focusing on justice. I'm proud, I've said before and I'll say it again, this is the best job I've ever had, and it's principally because of the people I work with. They believe in justice, and they put in the work to try to protect anyone who lives in this state. Every resident of this state receives the protection of this Office of Attorney General, and I'm proud of that. So it was my honor to be able to present that to you. I did not mention some of my employees by name, but understand that my top 5 include my first assistant, Craig Newby, my second assistant, Christine Jones-Brady. I mentioned my Solicitor General, Heidi Perry Stern, my Chief of Staff, Teresa Benitez Thompson, and who am I missing? And my General Counsel, Leslie Nino Pirro. That's the executive team that works so hard with everyone else to ensure that we get things done. So with that, Madam Chairwoman, I will tender the mic back to you and make myself available for questions if you have any. I know you have two bills of ours to hear, and hopefully we can satisfy any questions you have.
Thank you for that, Attorney General Ford. And we will get to questions. The first question is, and you sort of alluded to it, the size and scope of your office compared to maybe the Office of the Governor. Is the Attorney General's office the second largest or most robust office we have in the state?
Well, I say we have 350. We have nearly 400 PCNs available. We have 46 vacancies. So at fully staffed, we will have about 400 folks in our office. Frankly, I don't know where that compares to other state agencies. We tout ourselves, the DA Wolfson and I, we jostle back and forth about who has the largest law firm in the state, depending upon the day. But we are certainly one of the largest law firms in the state relative to the work that we do.
Okay, thank you for that. Members, questions? Our first question is from Assemblywoman Cohen.
Thank you for the presentation. Can you talk a little more about the ADR with the prisoners? What are the issues that are being addressed, and how successful has the program been?
Thank you. Do I go through you, Madam Chair?
No, please go direct.
Thank you. Thank you for the question, Assemblywoman Cohen. I'd be happy to ensure that we get more robust response to you on that. Chief Gilmer is the one who operates that, but it's a program that the U.S. District Court here in Nevada set up to allow us to mediate lawsuits that arise out of prison disputes. It could be something related to access to the commissary. It could be something related to toiletries. It could be something related to something a lot more substantive as well. But as you may know, prison litigation is expensive. It's plentiful, and it takes up a lot of time of the courts. And so the court instituted this program to allow us to have an intermediary step between some inmates filing lawsuits directly with the court to allow us to keep them from having to go there if we can get things resolved. We can get more information on that if you like, though.
Okay, so it's not about their case, it's about their imprisonment.
Yes, that's right.
Okay, thank you.
Yeah.
Doesn't seem to be any more questions. Maybe that was because you had such a robust, concise presentation, which we appreciate.
Thank you so much.
Excuse me?
I'm sorry.
Do you have a question, Assemblywoman? Proceed.
Thank you, Chair, for the indulgence. I can't type as quick as my brain gets the question. Just good to see you. Thank you for being here, all of you, and appreciate the big responsibility that you have and a great presentation and breaking that down. I had a question pop in my mind in addition to what my colleague, Assemblywoman Coleman, was bringing up with Department of Corrections. Just a clarification to help me understand. You explained that portion of her question. So when inmates have an issue that isn't maybe going to be a legal case, not pertaining to their incarceration, but they're just having trouble with, necessities or medical treatment. Do you have an ombudsman? Like, how does that work? What is the process? Because I unfortunately am hearing from constituents that are having trouble with their loved ones with certain services within the prisons. I also have the Lovelock prison within my district. And so I get communications that leave me wondering how streamlined and I'm trying to understand what that process is for an inmate who might not be getting the services they need, or the prices of things are too high. How is that handled, and through your agency or where? Thank you.
Thank you for the question. We serve as counsel to NDOC, to the Nevada Department of Corrections, and wouldn't necessarily engage in the day-to-day conversation around the things you're talking about. If litigation arises out of it, or if some legal issue arises out of it, then my office would obviously be engaged, and we may very well advise Nevada Department of Correction personnel on how to respond to certain inquiries and requests. I think the best thing for me to be able to do is to have Chief Randy Gilmer connect with you directly to answer any questions you may have, so that I don't misspeak today on the record. But as a general matter, I can say we work on the legal side of things, not really on the day-to-day interactions with the incarcerated individuals, with personnel there.
If I could just follow up to that real quick.
Continue.
Thank you for that. So, I guess that would be appreciated. And I'm just wondering what the check is on those who are handling that. Like, are you a check on the Department of Corrections? If things aren't getting done, who is the oversight for them to make sure that they're being prompted to do what their job is?
Well, a couple responses to that. First of which is, I've mentioned my 5 C's at the beginning of this, constitutional rights being one of them, and so we advise all of our clients from a constitutional perspective, from a consumer protection perspective, or whatever the case may be. So to the extent we see issues arise that we think need to be redressed or addressed, from an attorney-client perspective and relationship, we would have those conversations, which obviously wouldn't be aired out loud here. So that's one level of check, to the extent you want to consider that a check. But there is an agency that oversees, so to speak, NDOC, and that's called the Board of Prison Commissioners. I sit on that board, so does the governor, and so does the Secretary of State. And in fact, I think we have a meeting next week where we very well may be receiving information on some topics that are of import to you. So that board has some level of interaction with the Nevada Department of Corrections as well. So those are my responses again at this juncture, but I'm happy to have Chief Gilmer reach out to you directly, and we can arrange that to have a more robust discussion, if that's okay.
Thank you for that. Not seeing any other questions. Thank you so much for your presentation, and thank you so much. Attorney General, are you all staying for the bill presentation as well?
I'm not.
I'm staying.
Yeah, I have.
Okay.
Thank you. Thank you so much, Madam Chair. I appreciate that.
Yes, thank you. And we happy to have you in our committee today. With that, I will go ahead and close the presentation from the Office of the Attorney General. Our next presentation will be a bill hearing on Assembly Bill 49, and Chief Heather Proctor is presenting that bill, and she's already at the table. And with that, this bill revises provisions relating to criminal procedure. So, Chief Proctor, whenever you are ready, please proceed.
Thank you. For the record, Heather Proctor, Heather Procter. I am the Chief Deputy of the Post-Conviction Division of the Nevada Attorney General's Office. AB 49 seeks to amend NRS Chapter 34 regarding petitions filed by inmates after they are sentenced to a crime in Nevada. These petitions are referred to as a petition for writ of habeas corpus or a post-conviction petition. Under Chapter 34, there are essentially two categories of post-conviction habeas petitions, one in which the petitioners challenge their sentence or conviction, and the second in which petitioners challenge the Department of Corrections' computation of time served. There are different procedural requirements for each, depending on the type of petition filed. For instance, under existing law, petitions challenging the conviction must be filed in the county where the inmate was convicted, while petitions challenging the computation of time must be filed in the county where the inmate is currently incarcerated. And a petitioner cannot challenge both their conviction and time calculation in the same petition. Unfortunately, these differences are sometimes buried in the fine print and can be difficult to navigate in practice. So the intent of AB 49 is to simply clarify the existing law as to the different procedures and requirements for the two types of petitions. This will make it easier for an inmate to properly file a petition without an inmate, for attorneys who litigate such cases, and for the district courts that address these petitions. First, we seek to clarify and distinguish the two types of petitions through sample forms. Existing law provides a sample petition challenging conviction, but not to challenge the computation of time. Section 3 of the bill creates a form petition to challenge time computation. Second, currently in Chapter 34, the language as to which agency responds to such petitions is somewhat inconsistent and can be confusing. The confusion was intensified when the legislature in 2019 created a subtype of post-conviction petition, a petition for factual innocence. And as a side note, we're not going to be talking about factual innocence petitions as a type of petition, that's simply a subtype. To create clarity, Section 2 defines a prosecuting agency as the agency that prosecuted the crimes and then uses that phrase throughout the bill. While the prosecuting agency is generally the county district attorney, the Attorney General's office is also authorized to prosecute certain crimes. By contrast, we did not change existing law that requires the Attorney General's office to respond to a time challenge action. Third, Section 26 repeals the existing requirement to file a return with the court. A return is a document prepared by the custodian of the petitioner, generally the Department of Corrections, that demonstrates the person is currently incarcerated or under supervision. As the responding agency to either type of petition, generally provides proof of a judgment of conviction and addresses the custody status of the petitioner in the normal course of litigating such petitions, there is no need for a return. Instead, we moved the requirement to provide proof of the judgment and/or custody to the responding agency's response or answer to the petition, as reflected in Sections 13, 14, and 16. Fourth, with this wholesale clarification of Chapter 34, several sections include minor clerical changes to update the original language from the 1980s. Finally, the Attorney General's office submitted a proposed amendment to AB 49 that we inadvertently left out of the original bill. This amendment addresses a provision in Chapter 178 regarding the custody status of an individual when a court grants a state post-conviction petition. The intent of this amendment, consistent with the existing provisions of AB 49, is to provide clarity as to what type of petition such relief applies. In closing, AB 49 does not seek to change the law or procedural processes already in place for post-conviction actions. The purpose and intent of AB 49 is to clarify the differences between the two types of petitions and to provide guidance within the existing statutes to explain the procedural rules associated with each type. In doing so, AB 49 preserves inmate rights while promoting judicial economy and clarity in the law. Thank you.
Thank you, Chief Proctor, for your presentation. Sorry about that. With that, we will open it up for questions. Our first question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this presentation. While I was reading this, I was just wondering how often petitions come in incorrectly and what happens when that happens.
Thank you. For the record, Heather Proctor. What generally happens is we do have, under existing law, the ability for the court to transfer the case to the correct county. The difficulty is having the clerk properly identify the case as either a challenge to the conviction and sentence or to the challenge of the time calculated. So when we have for instance, a time challenge, very frequently the inmates will file those in the incorrect county. They'll file them in the county of conviction. And so we identify that, we file a motion to change venue, and we have the petition transferred to the appropriate county.
Thank you for that question, Assemblywoman. I did, before we continue with questions, you did reference an amendment, but we don't have it yet. Is that still coming? Okay, so we'll move on. We'll continue with questions then. The next question is from Assemblywoman Bilbray Axelrod.
I think my question will be very brief. Would it be okay if I ask two questions separately? They're both
Let's
very-
just start with one right now.
Okay. Well, let me decide. Okay. Well, I was looking at the amendments that, or I don't know if it was a friendly amendment, but I did see that there is an amendment asking if you guys would, if you would consider putting posthumously. So, and I know that's a big issue, right? You know, we have people who come in here every day talking about their loved ones who have, you know, died. So, would you consider that?
For the record, Heather Proctor, we are not considering that amendment. Our intent with this bill is simply to clarify the existing law, not to alter or change the processes. And so we felt that that did change the process, and so we are not supporting that proposed amendment.
Okay, thank you. Our next question is from Assemblywoman Considine.
Thank you, Madam Chair. Thank you for the presentation. On the time computation form, is there, what's the time limit for that? I guess on both sides. Is there a time limit where somebody needs to file this? And then how long, if someone is asking about the computation of their time, what's the time limit for them to get a response? So kind of, how long do they have to file it and how long to get an answer?
For the record, Heather Proctor, there is no real time limit for an inmate to file a challenge to their time computation. The Nevada Supreme Court has actually determined that the one-year time limitation that applies to conviction or sentence petitions does not apply to the computation of time, because that is an ongoing calculation. And so there's no limitation on when an inmate can file a challenge to their time computation. The only real limit would be, for instance, if they're challenging the calculation for parole eligibility. If they've already been considered by the parole board, that consideration would be moot because they don't have any other remedy. As far as a response, the court will generally provide us, I believe, 30 to 45 days to respond to those petitions.
Thank you, Assemblywoman. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Thank you for the presentation. On section 15, it references stating whether or not the petitioner is in custody or under the respondent's power or restraint, and contemplates, I think, in those subsections that the petitioner would potentially not be in custody. Under what circumstances would there be a petitioner not currently in custody of NDOC?
Heather Proctor, for the record. So for instance, individuals who are on probation would not be supervised through the Department of Corrections. They would be supervised through the Parole and Probation Department. There are also certain requirements for certain petitions that require the inmate to actually be in custody in order to bring their challenge. And that custody can be through Department of Corrections, it can be through parole and the parole board, or it can be through probation.
Thank you for that. Assemblywoman Summers Armstrong.
Thank you, Madam Chair. With this, how do you all distribute these forms, and how are they accessible to those who are incarcerated? Is there a library? Are they easily accessible? Is there if it's online, do you have like a step-by-step instruction to help people get this done so that it can be put together as cleanly as possible?
Yes, once again, Heather Proctor for the record. These forms are provided through the law library of each institution, and they're not necessarily provided with self-explanatory instructions, but the library is generally provides some sort of instruction on how to file these petitions.
Continue.
So considering that this is a humongous effort to recreate these forms in a manner that you believe will help move this process through the court a little bit faster, why not give some type of clear instruction so that there's not delays? Because I'm going to guess that if things are not right, you all send it back and have to start all over again. Am I correct?
So Heather Proctor for the record. As far as including instructions, that's certainly something we would be happy to consider. There are other forms, such as for federal habeas petitions, that do come with a cover sheet with instructions. So we could certainly adopt something like that for both of these bills, or for both of these forms. As far as if an inmate does not fill it out properly, we do not send it back. We do address it to the best of our ability. If we can understand what they're trying to say, then we will address the claims on the merits. If the petition is filed in the wrong county, which is actually quite common, then we will work to get it into the correct county.
Yes, Assemblywoman, I'd like to follow up on that question as well. So it's still, excuse me, I'm going to ask presenters for the rest of the entire session to make sure we're in those middle seats, because I'm just not the tallest chair ever. I apologize. The question really about what about providing some instruction, especially because it is changing. So it sounds like we're kind of, there could be, maybe depending who's there that day, they may just kind of out of courtesy offer a few helpful hints. But where are we really? Because I know when I first sat on this committee back in 2017, there was a question about inmate release forms before they could leave prison. And that I was really upset to hear that the onus was put on the person that was incarcerated, and they weren't getting the proper assistance and guidance to facilitate this. So again, with this, especially with it being new, will there, can there, why not? Because I feel like that's what we're, really looking out for Nevadans. Could you just please respond to that assistance part, that instruction part, to ensure that they are filling it out correctly and that people just don't get caught in a cycle of repeat?
Once again, Heather Proctor for the record. I would be happy to do that, and I would be happy to submit an amendment to actually include the instructions as part of the forms.
Well, thank you. I think that is highly acceptable from everyone up here. Thank you. Moving on, our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for being with us this morning. So I just had a question about the fact that these forms are actually being written into statute. Do you foresee that being an issue if there's a mistake or you need to change something? Because once they're in statute, you'll have to wait for us to come back around to make those changes.
For the record, Heather Proctor, the forms for a petition challenging a conviction or sentence have been on the books for since about the 80s. We are making a few clerical changes this time to that form. As far as the time calculation form, we try to be as inclusive as possible to cover any potential claims. Is it possible we'll have to amend the form? Certainly. But we wanted something consistent that every library would have in order to provide every inmate. And that includes defendants who are not incarcerated, who may not have access to a law library, that they could use the statute to pull the correct form.
Thank you for your question, Assemblywoman. Next question is from Assemblywoman Hardy.
Thank you, Chair, and thank you for this. Working in the courts for many years, I had experience getting these writs in handwritten, and so I appreciate your efforts to try and simplify these for individuals. Again, not familiar with navigating the courts and things, so I appreciate this bill. My question is in Section 8, where you say the person must not be required to pay filing fee. Are there currently filing fees for these? And this is saying they're not, or just do they currently have to pay a fee to file these?
Heather Proctor, for the record, my understanding is no, there are no fees associated with either type of petition.
Thank you. Our next question is from Vice Chair Marzola.
Good morning, and thank you for your presentation. How many of these petitions are filed per year?
Heather Proctor, for the record. So for the time credit challenges, we get about 300 a year. We hit a max of almost 2,000 one year as a result of a Nevada Supreme Court decision. And so it is not a consistent number. It really depends on the status of the statutes. So for instance, if we receive a new time credit statute this year, we will see an uptick of probably doubling that or tripling that in the next year. As far as petitions challenging convictions or sentences, I can't give you a number as we don't address most of those, but it is a very high number of petitions that inmates file.
Follow-up, Chair?
Yes, please.
Do you know why you don't, take those into consideration?
I'm sorry,
For the sentence?
For the record, Heather Proctor. So the petitions challenging a conviction or sentence are generally handled by the prosecuting agency, which is generally the district attorney. Our office only handles petitions challenging a conviction or sentence that we actually prosecuted. And so for the ones that we actually prosecute, which is a fairly small number compared to the number of prosecutions throughout the state, we see perhaps 5 to 10 direct appeals or state habeas petitions challenging those convictions or sentences every year.
One last follow-up.
Please.
Thank you, Chair. Out of all of these petitions that are filed yearly, are any of them dismissed or sent back because they're not filed correctly?
Heather Proctor, for the record. I can't speak to the petitions challenging conviction or sentence. Once again, those ones that are actually filed with the DA's office. With the petitions challenging a conviction filed with our office, those are not rejected. We do address those. They are subject to procedural bars that are already in place, such as timeliness or successive petitions. So it's possible that a petition could be dismissed on procedural grounds, but we do not reject them if they are not on the proper form or they don't address all of the questions. The same with the time credit challenge. And even with the time credit challenges, if we're moving it to a different jurisdiction, it is our policy to always look at that time credit challenge to make sure there isn't something that needs to be addressed immediately before we do transfer those.
Thank you. Thank you, Chair.
Thank you, Vice Chair. With that, I will go ahead and open it up for testimony. So if there's anyone here in Carson City that would like to testify in support of Assembly Bill 49, please approach. Again, just reminding everyone that you will have up to 2 minutes for your testimony, and that this is, again, just reminding folks that we are testifying in support or opposition in fully as it has been presented today with the proposed amendments that we are expecting to come. So opening it up for support, please proceed when you're ready.
Tanya Brown, spelled Tonja, B-R-O-W-N, Advocates for the Inmates and the Innocent. We do support this bill. I was hoping to have the proposed amendment on the factual innocence to be supported. But I do want to mention something that was not mentioned by the Attorney General's office, and that is dealing with wrongful convictions and how the Attorney General's office is involved in carrying out wrongful convictions unknowingly.
So, Ms. Brown, are you supporting the bill in its entirety?
I am, but I would like to have our proposed amendment to this bill to be considered and discussed. But in the long run, the Attorney General's office unknowingly will fight the conviction,
Right, but
wrongful
Ms.
conviction.
Brown, this is to testify in support
Right, and we are
of the
in
bill.
support. We are absolutely in support of this bill.
Okay, thank you so much.
you.
And also, thank you for reminding us that we need to say our name and spell it for the record. So thank you for that as well.
Good morning, Chair. Jennifer Noble, Jennifer, Noble. On behalf of the Nevada District Attorneys Association, we are here in support of AB 49 today. We believe that Ms. Proctor and the AG's office have done a good job of cleaning up some confusing language that's in current statute. And I also think that this will help out the process that we see where, for example, in Washoe County, I might receive in our post-conviction division a petition from an inmate, and they're simply asking for calculation of time credits, which, as she explained, can't be heard in Washoe County. It has to be heard in Carson. And so then what I have to do is move to transfer the case, and that just takes time away or makes it take longer for the appropriate court to consider the applicant's petition. So we're in support. Thank you.
Thank you. Is there anyone else here in support of Assembly Bill 49? All right, anyone in Las Vegas that would like to testify in support of Assembly Bill 49? Okay, broadcasting, please open the lines. I will provide that number for anyone wishing to testify in support. It is 1-669-900-6833, and today's meeting ID is 898-288-21744. So broadcasting, please, whenever someone is available, if someone is interested in testifying.
Yes, Chair. If you would like to testify in support of Assembly Bill 49, please press star 9 now to take your place in the queue. Callers, if you would like to testify in support of Assembly Bill 49, please press star 9 now to take your place in the queue.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIEGRANT. I am in support of AB 49. Again, I am in support of AB 49. I would like our amendments considered. The idea that we don't need posthumous language added because it changes the process is interesting. Truth be told, there are no other remedies besides this legislature amending AB 49 to add the posthumous language for a deceased wrongfully convicted person to be exonerated. The AG's attempt may be to clean up the language, but I urge you all to use it as an opportunity to level the playing field for all, including the deceased. Would we have just said, oh, well, if DeMarlo Barry died in prison wrongfully
Oh, okay,
convicted
Ms.
before
Grant,
he
are you,
had his day?
Ms. Grant, are you supporting the bill
I am in
as?
support of the bill,
Okay, thank you so much.
as is.
Thank you. As is, thank you, we appreciate that. Next caller?
Sarah, there are no other callers choosing to testify at this time.
Thank you. With that, we will close testimony in support and open it up for testimony in opposition. If there's anyone opposing Assembly Bill 49 here in Carson City, please approach. Not seeing anyone. Is there anyone in Las Vegas? Also not seeing anyone. Broadcasting, is there anyone on the line that would like to oppose Assembly Bill 49?
Callers, if you would like to testify in opposition to Assembly Bill 49, please press star 9 now to take your place in the queue.
Hi, my name is Jim Hoffman. I represent Nevada Attorneys for Criminal Justice. We are not opposed to the overall concept of this bill. We think a clarification is reasonable and we would support that. But there's a specific technical problem. And I want to apologize to Chief Proctor for not addressing this beforehand. If you look at Section 9, that amends NRS 34726, which is the time bar. This is what Assemblywoman Considine was asking about. Right now, it says that you have to file a post-conviction petition within 1 year after conviction. But as Chief Proctor said, there's currently no requirement, there's no time bar for filing a sentence calculation petition. This bill, the red cross out there, that would remove that. So it would apply the 1 year time bar to a sentence calculation petition. And that's a problem because, inmates often don't realize that they have a sentence error until after it's been a year. The error might not happen until more than a year has passed. And just overall, it's kind of, we believe it's not very fair to put a time bar on this. So I understand from Chief Proctor's testimony that that was not the intent of the Attorney General's office, and hopefully we can work with them to get that technical fix in, because we currently oppose the bill. Thank you.
Thank you for that. And just so you know, because you're not in the room and able to see, Chief Proctor and Chief of Staff Benitez Thompson and other staff members are taking notes right now and nodding their heads. So they completely hear you. And is it fair to say that's something you'll consider? And yes, it will be considered. So thank you for bringing that up. With that, next caller.
Callers, if you have recently joined and would like to provide testimony in opposition to Assembly Bill 49, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to participate at this time.
Okay, thank you. We will open it up for testimony in neutral. If there's anyone that would like to testify in neutral here in Carson City, please approach. Not seeing anyone. Anyone in Las Vegas that would like to testify in neutral? Broadcasting, is there anyone on the line that would like to testify in neutral?
Callers, if you would like to testify in neutral for Assembly Bill 49, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to participate at this time.
Thank you. With that, I will welcome Chief Heather Proctor back up if you would like to make some final remarks.
For the record, Heather Proctor, we will be reviewing the bill for those amendments that we've discussed today. We will be submitting those.
We appreciate that. Thank you so much. And with that, I'll go ahead and close the hearing on Assembly Bill 49. Our next bill hearing is Assembly Bill 51, which will be presented by our DAs John Jones and Jennifer Noble. This makes various changes relating to public safety. With that, I will welcome you up to the table. And DA Noble, do you mind moving to that one? Just, thank you. Thank you so much for that. These chairs were not necessarily created decades ago for a female majority, so thank you so much. With that, I will officially open up the hearing for Assembly Bill 51, and when you are ready, please proceed.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and along with Jennifer Noble, we're here on behalf of the Nevada District Attorneys Association. First and foremost, we want to thank Attorney General Ford and Chief of Staff Benitez Thompson for sponsoring AB 51 and working with us on this bill. And the original language of AB 51 proposed to do a few things, including giving law enforcement up to 14 days to effectuate an arrest after someone is alleged to have committed an act of domestic violence. It added attempts to the definition of domestic violence. It provided a protective order violation exception to Nevada's two-party consent statute for recording of telephone calls, and it further cleaned up some errors in the NRS. After AB 51 dropped, we did have stakeholder meetings that included the Attorney General's office. It included Nevada Coalition to End Domestic and Sexual Violence, the public defenders, defense attorneys, law enforcement, and others. And based on those stakeholder meetings, we have come up with an amendment that is on Nellis that I believe addresses everybody's concerns. And we will be working off of that amendment this morning. That amendment does three basic things. The first, it gives law enforcement up to 7 days to effectuate an arrest if there's probable cause to believe that battery domestic violence has been committed and the person is not on scene when officers first arrive. The second thing it does is clean up an enhancement when a crime is committed while the person who commits the crime is under a protective order. And then third, it makes domestic violence non-probationable again. So I'm going to turn it over to Jenny Noble to talk about the first thing.
You're right, these were not set up for some of the shorter people because I can barely reach the microphone. Good morning again, Chair and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. I want to call your attention first to it's sections 1, 2, and 3 of the bill. Right now you'll see interlineated a 24 hours to 14 days. As Mr. Jones explained, that's going to be 7 days pursuant to the amendment. But I want to give you a little bit of background about why we wanted to give more time. Under current law enforcement responding to a domestic violence call must arrest the perpetrator if they have probable cause within 24 hours. That's if they get there and the alleged perpetrator is there. They must effect that arrest if probable cause supports it. But if the perpetrators fled, which often happens, police only have 24 hours to locate them in order to effectuate an arrest. For example, if the perpetrator shows back up at hour 25 at the victim's residence, police can no longer arrest based on probable cause connected to domestic violence. Their only alternative is instead to submit for an arrest warrant application, and by their nature, arrest warrant applications take time. Police must finalize all reports, including photographs. 911 recordings have to be requested and obtained, and witness statements have to be gathered by law enforcement. And once they've got that package together, they have to pass it along to the prosecutor's office. Then a prosecutor has to review all of that information and determine whether or not we agree that there was probable cause to arrest and whether or not this is a case that can be prosecuted beyond a reasonable doubt. From there, if the DA makes the decision that this case is one that should be charged, it also has to go to a judge. So you can imagine the time that's passing. This takes many, many days, sometimes up to 60 days for it to move through the system. So in changing that 24 hours to 7 days, which was part of negotiations, we're hoping to give victims a little bit faster response time in terms of moving their case through the justice systems. That doesn't mean that domestic violence calls don't remain high priority. They are almost the highest priority, absent something like 1 October. These are extremely important to law enforcement, and nothing in this bill would alter that. They still have to try to locate for 24 hours, and it's only after they're unable to do that does the 7-day extension, for lack of a better term, kick in.
John Jones on behalf of the Nevada District Attorneys Association. The two remaining sections that we're dealing with are sections 14, which is not in the amendment because that is not being amended, and section 16. So section 14 amends NRS 193.166, and that is an enhancement statute. And if you commit a felony, and while committing that felony, you're also in violation of a protective order, current law says that you can be punished by an additional penalty of 1 to 20 years. However, it goes on to say that if the underlying crime is punishable as a category A or B felony, our most serious offenses, the additional punishment is a 1 to 5 year term. So clearly those two numbers are flipped. It should be 1 to 5 and 1 to 20 if it's a category A or B. So all this does is flip those numbers and correct that error that was in the NRS. And turning to section 16, last session, the legislature passed AB 42, and that bill was amended a few times, and during some of the final amendments, language was changed that inadvertently made felony domestic violence probationable. It was not listed in the title of the bill last session. It was not testified to. In other words, it was a completely inadvertent change that nobody caught. So all of this does is reinstate language in statute that makes felony domestic violence, battery domestic violence, probationable. And with that, Madam Chair, members of the committee, we're happy to answer any questions you may have about AB 51.
Thank you for that presentation. With that, we'll open it up for questions. Our first question is from Assemblywoman Mosca.
Thank you, Chair. Thank you for the presentation. Do you have the data, or can you get the data of how many more people would be arrested if it was changed to the 7 days?
John Jones on behalf of the Nevada District Attorneys Association. We can look to see if we can find that data. It's a great question. I just don't know if we keep stats on when somebody is arrested in relation to when they committed the crime. We may track that. I don't know if we do.
Our next question is from Assemblyman Gray.
Thank you, Madam Chair. Good morning. So when these domestic violence issues happen and the perp isn't arrested within the 24 hours, first question is, how long does it, how many of those actually go to an arrest warrant since they've, fled and already evaded that? And couldn't this be creating actually more work for officers on the ground and ultimately more work for you guys, especially in cases like this where, given the extended time, the victim may no longer see herself as a victim anymore, shall we say, or he no longer sees himself as a victim anymore, where if they're not willing to testify is what I'm getting at.
John Jones on behalf of the District Attorneys Association. I will note that time is not our friend in a case. The earlier that we can effectuate an arrest and get the case started, the better off I think we're going to be as a system. Oftentimes when we're talking about arrest warrants, the alleged perpetrator is often arrested months after the offense, and at that point, we're really at the mercy of where the family, the defendant, and the victim are in the cycle of violence. And we are often intervening in a time when everything's pretty stable. And at that point, the victim doesn't want to testify because everything's fine at this point in time. So with domestic violence specifically, the earlier we intervene, the better. And so our intent with this is to intervene earlier.
Thank you.
Thank you, Assemblyman. Our next question is from Assemblywoman Gallant.
Thank you, Chair. So I'm curious when the time clock starts. Like, what is the precipitating event where you start getting that 24-hour to 7 days? And also considering how highly skilled the batterers are, do you find that they wait 25 hours to show up? And are you concerned that they're going to wait 7 days and 1 hour?
Thank you for the question. Chair, through you to the Assemblywoman.
Please go direct.
Thank you. So I think your first question was, do we often find that batterers turn up at the 25th hour, and are we concerned that they're going to wait till 8 days or 7 days and 1 hour? That's always a possibility, but the reality of the situation is it's a lot harder to hide out for 7 days than it is for 24 hours. And so that's our thinking here. And I don't know if that answers your question. I think you asked two questions.
Well, I was curious when the...
Sorry. Want to follow up?
Yes, please. Thank you.
Proceed.
What is the precipitating event that starts the time clock?
Jennifer Noble, for the record, thank you for the reminder. You did ask that question. So what would start the time clock is probably the time that the battery occurs and we get the call from the victim, the 911 call or the call to dispatch or the call from a neighbor that there's a disturbance at the residence and probable cause is determined. that domestic battery has occurred. Once that probable cause is determined, that's when the clock starts ticking, because now we have probable cause to arrest the perpetrator.
Next question from Assemblywoman Bilbray Axelrod.
Thank you, Madam Chair. My question is in section 16, when we're talking about the ability to grant probation or suspend the sentence. I know it's giving that if it is a misdemeanor, but then not allowing it if it's a gross misdemeanor or a felony. Could you just tell me the difference between a misdemeanor and a gross misdemeanor in domestic violence?
John Jones on behalf of the Nevada District Attorneys Association. Battery domestic violence first and second is a misdemeanor in Nevada law. So that would be anything that does not rise to the level of substantial bodily harm and in situations where a weapon is not used. Felony battery domestic violence would be if substantial bodily harm exists, if a weapon was used, or if they have twice been convicted of a misdemeanor battery domestic violence in the preceding 7 years. The gross misdemeanor would be a battery on a pregnant person. That is the only gross misdemeanor crime that we have right now. Battery domestic violence on a pregnant person.
Thank you for that. Our next question is from Assemblywoman Summers Armstrong.
Thank you for your presentation. So I'm trying to imagine what happens if day 3, the police find that someone is at their cousin's, aunt's, somebody's house, and they go to make an arrest. When they're announcing themselves at the door, and that person says to them, because we have quite a few folks who watch all the things on television, and they're going to say, "Do you have a warrant?" How does the police deal with that? Because you're saying that for some reason you can't get a warrant in 7 days, so that you need to be able to arrest without a warrant. How do you deal with that? Because I would guess that you're going to get pushback from that person if they say, "Do you have a warrant?" and you don't have one.
Jennifer Noble for the record. Thank you for the question, Assemblywoman. So I want to first just distinguish, just to make sure we're all on the same page, warrants for arrest versus search warrants for residence. So if we have a probable cause to arrest an individual, that doesn't mean necessarily that the police can enter someone else's residence to find that person. They usually need to wait until the person leaves the residence and do it that way. So this would not give carte blanche because you have an arrest warrant for a person, or a probable cause rather, to arrest someone. That doesn't give carte blanche to law enforcement to kick down a door, to demand to be let inside a house because they know the person they have probable cause to arrest just happens to be inside.
Proceed.
Okay, thank you. So I understand the premises, but we're still not addressing the issue of the approach of the person that you were trying to arrest. Whether you are picking them up on the street, the grocery store, in the Walmart parking lot, you're approaching that person and you're going to tell them that they are under arrest. And if they ask you, "Why do you have a warrant for my arrest?" and you don't have one, what is the response to that person?
Thank you. John Jones on behalf of the Nevada District Attorneys Association. I will say I think that is a question that's probably better presented to law enforcement. I think the last thing that you all want is Ginny and I acting as law enforcement officers. But I do want to point out that oftentimes what we're seeing is that law enforcement is being called back to the residents that they were originally called to. And the 24-hour time frame has passed. And at that point, as long as there has not PC for a new crime, law enforcement cannot arrest on the original battery domestic violence. They have to wait until the warrant is actually signed by a judge. So what we're seeing generally is law enforcement being called back to the original residence, but the 24-hour period has passed. So that's generally how the alleged perpetrators in these cases are being found.
I would like to follow up to that question. Can you tell us how long it's actually taking then to file those arrest warrants?
John Jones on behalf of the Nevada District Attorneys Association. It can take months, especially when you've got the law enforcement community that needs to put the arrest warrant packets together. And the DA's offices generally require that arrest warrants be submitted to us in states that all the discovery is there, as Jenny indicated, the body cam footage, any surveillance video, witness statements. Then my office reviews it for probable cause and to see whether or not we're going to approve it for arrest. Once a screening deputy approves it, then it goes to a secretary to type. After the complaint is typed, the whole case then goes to a judge. And then we're beholden on how quickly the judge reviews it and determines whether or not they're going to issue an arrest warrant. Once the judge has determined that, it then has to go to a data entry person to enter it into the computer systems so that officers on the street can actually see that there's a warrant out for that person's arrest. That all takes time, and we're often dependent on people who are not necessarily within law enforcement community, such as judges. So it takes time, and often when we're dealing with domestic violence, that time matters.
Thank you for that. Our next question is from Assemblywoman Cohen. Thank you, and thank you for the presentation. So I have a question about Section 2, and it seems like there's some inconsistency in the language. In Section 2 at the beginning, so sub 1, it says, except as otherwise provided in subsection 2, whether or not the warrant has been issued, a peace officer shall, unless mitigating circumstances exist, arrest a person when the peace officer has probable cause. I don't think the other sections have that unless mitigating circumstances exist. What is that unless mitigating circumstances exist language, and why is it not consistent throughout? And doesn't that kind of alleviate the need to have the 14 days, because that gives you that gives the officer, the mitigating circumstances gives the officer that the ability to have more time than 24 hours.
Jennifer Noble, for the record. So the way I read that section is that it's requiring mandating an arrest if the person is located within 24 hours. It does have that mitigating circumstances language, and I imagine that might be in circumstances in which we have an alleged perpetrator who has a medical condition, or they have checked into a rehab facility or something like that. As to why it's not like that throughout the bill, I don't have an answer for you right now. We took this from the existing statutes, so it has always been inconsistent if it's inconsistent, and we can certainly chat with you offline and provide an answer to the committee that better addresses your question.
Thank you for that. Did you have another? Yeah. Okay, the Assemblywoman has a second question. Okay, Thank you. Yeah, I would like to understand that more, because that didn't make a lot of sense to me. Then, can you just go through, I'm sorry, now I lost my page. Going back to Section 14, the year, so what are we ending up with? Those changes in Section 14, just explain those changes to me again, please.
John Jones on behalf of the Nevada District Attorneys Association. So in Section 14, there are two numbers that were basically transposed. It says that it generally says that if you commit a crime while in violation of a protective order, you're subject to an enhancement of 1 to 20 years. However, if you commit an A or B felony, the additional punishment should be a term of 1 to 5 years. Those numbers are transposed. And the reason we know they're transposed is the additional penalty cannot be longer than the underlying penalty. So, for example, if you commit a battery substantial bodily harm, it's punishable by 1 to 5 years. If you do commit battery substantial bodily harm while you were under a protective order against the victim, then you can be punished by an additional term of 1 to 5 years. So the C, D, and E felonies, the maximum range is 5 years. And since the enhancement can't exceed that, then it makes sense that that number should have originally been 5 years. With respect to A and B felonies, we're talking about charges with potential life tails, so the 1 to 20 makes more sense there. I hope that answers your question, Assemblywoman.
Yes, thank you. Thank you, Assemblywoman. Our next question is from Assemblywoman Hardy.
Thank you, Chair. Good to see you guys today. If we could go to section 1611, if you could just maybe give more information about when a person committed of DV can be on probation and when they can't, or have a sentence suspended. I understand when it's a felony they can't, but there's A and B says when they cannot, and then when they may grant probation. So if you could just kind of expand on those two conditions. Thank you.
Thank you. John Jones on behalf of the Nevada District Attorneys Association. So this would make basically any domestic violence that's not a felony, you would be eligible for probation. So battery domestic violence first, battery domestic violence second. It would not change any current practice that we currently have in place. So all this would do is fix the error that was made in statute last session.
Thank you, Assemblywoman. With that, I don't see any additional questions for you all, but I would like to, before we move into testimony, welcome Detective Hunt and Sergeant Walker, if you would be available for questions, because the members do have some specific questions from the law enforcement angle. And again, I'm not asking you to necessarily answer questions on the bill per se, but if we have questions pertaining to just procedure and process and kind of what it looks like from your angle from law enforcement, if you're available for that.
Good morning, Chair Miller, and good morning, members of the committee. Jason Walker, Washington County Sheriff's Office. My colleague Adrian Hunt and I are hopefully have answers to your questions. I'd like to first go right back to Assemblywoman Summers Armstrong question regarding at the 25th hour, we find somebody, whether they're walking down the street, 7-Eleven, whatever, and the way that it's currently written, we have the 24-hour shall arrest. If this were to go through and we're at day 3, I don't need a warrant. I have probable cause to arrest this person. So I hope that that circles right back and answers that question for you, ma'am. Washington County Sheriff's Office stance on this bill, I participated in the working group for AB 51, and I believe this bill is for the right reasons, for victim assistance. Having worked patrol as a deputy and having managed deputies on the supervisory level on patrol, it is a high priority call for service. It is one so much so, it's probably one of our most frequent calls for service, as Assemblyman Urick with his law enforcement background could attest to. Highly emotionally charged calls for service. In 2015, Carson City Deputy Carl Howe was killed in the line of duty responding to a domestic violence call. I think, obviously the response and investigation and probable cause development, we notify all persons that are attached to patrol that we have the probable cause to arrest this person. We provide that information between covering shifts. If we have to have a special briefing or whatever to say that we're looking for so-and-so, we provide that information. By moving that timeline from 24 hours to 7 days, it allows us more time to contact these persons to arrest them. Therefore, as DA Jones presented, we present our case for prosecution as closed by arrest. I believe it's cleaner at that point. All information can go in at one time. That's my view on this. I'm sure Detective Hunt has additional information.
Adrian Hunt, for the record, ADRIANHUNT. Thank you, Madam Chair and committee. I echo the same sentiments as my colleague here. Of course, domestic calls are, important calls. Priority 0 for us as well. We actually responded with a minimum of 2 officers. arrested. So we lost an officer the end of 2022 as well. He responded to a domestic call as well. So again, we do take these calls very serious, and we hope and we think that this bill would definitely help us as well. Thank you.
Thank you for that. We do have a question from Assemblywoman Newby.
Thank you, Madam Chairwoman. Echoing one of the questions of my colleagues, what proportion of domestic violence cases do you think you would be able to arrest on with this expansion of time?
Thank you for the question, Jason Walker. I would have to circle back on that. I will get with our intelligence center to see if, because I know when we make these arrests and I know when we submit for that warrant. I wish I had an answer for you currently, but I don't. But I will note that and circle back to you on that because I'm curious as well.
Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for jumping right up at the call of the chair. So my question is similar to my colleague Assemblymember Summers Armstrong. So we know that you have the ability under this bill to arrest on day 3, but I think, as she said, many people are taught, if police come to you, say, do you have a warrant, right? And so what is your response, even though you have the authority? What is the response to the individual that you are arresting? And then additionally with that, do you agree with the DA's timeline that it takes months to get that arrest warrant, or do you find that it is different?
Thank you for the question, Jason Walker, for the record. My response to the first question of do you have a warrant, I think that might be an uneducation piece on the person that I'm arresting. Oftentimes people say you can't ask me questions because you haven't read me my rights. Well, I'm not asking them incriminating questions. I'm asking if they're okay or something along those lines. So I will throw that into that lane.
Adrian Hunt, for the record. From my experience, we definitely, again, a minimum of 2 officers. From my experience in patrol, I've never really had issues with somebody, being defiant when it's regarding DV. Usually, a lot of them understand and know why we're there. But again, I think this helps us because a lot of times they know the 24 hours, after 24 hours, they're going to be gone for 24 hours, then they'll come back. So I think this helps us. And of course, with our policy, we have to be safe and strategic about it. And again, I don't think it's something that we will go on a high-speed chase for. If that's the case, if somebody jumps in the car and drives away, that's definitely not going to happen. But this definitely helps because, again, within that 24 hours, it's usually an issue for us to locate someone regarding that they know that they may possibly be under arrest.
Thank you for that, and thank you so much for your willingness to come up and answer some impromptu questions. But I know that when you're available, and again, people have real questions about what this looks like in daily, practice. So thank you for that. With that, I will go ahead and open it up for testimony. So I will open up testimony for Assembly Bill 51. Again, if there's anyone here in Carson City that would like to testify in support for Assembly Bill 51, please remember to say and spell your name for the record, and you will have up to 2 minutes.
Good morning, Chair Miller, members of the Judiciary Committee. For the record, my name is Serena Evans, Serena EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. First, I'd like to thank the district attorneys for their work on this bill, allowing us to be here in support of AB 51 today. Leaving an abusive partner is the most dangerous time for victim survivors, with the risk of homicide increasing by 500%. Knowing that, victim survivor safety and perpetrator accountability must be prioritized when law enforcement responds to domestic violence calls. It is not uncommon for the perpetrator to flee the scene once law enforcement has been dispatched and lay low in the subsequent days. Following the typical cycle of abuse, it is also not unusual for the perpetrator to show back up in a few days to try and reconcile with the victim survivor or to further intimidate or harm them. In these instances, while there may not be a physical altercation yet, victim survivors feel a very valid and real terror. Typically, it is only a matter of time before another instance of physical abuse, or worse, homicide, occurs. The current 24-hour arresting period limits the actions that can be taken in these scenarios and leaves victim survivors fending for themselves without protection. A victim survivor should not have to endure any more abuse for an arrest to be made. We believe that increasing the time frame for arrest will positively impact victim survivors, their safety, and may even save lives. Thank you.
Thank you, Nicole Riley. For the record, NICOLEREILLY. I'm the Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking at the Nevada Office of the Attorney General. Despite multidisciplinary efforts over the past 10 years, Nevada continues to enjoy the distinction of being, on average, in number 7 in the nation for domestic violence and domestic violence fatalities. In fact, according to a report published by the University of Nevada at Reno, it is more dangerous to be a woman living in Nevada than it is to be a police officer in our state. That is astounding. Nearly half of Nevada women will experience physical violence, sexual assault, or stalking from their intimate partner in their lifetime. Over a third of Nevada men will experience this as well. AB 51 addresses 2 specific obstacles currently faced by law enforcement. First is the expansion of the time given to a police officer to make a discretionary arrest from 24 hours to 7 days. Perpetrators of domestic violence often go into hiding, avoiding arrest. This limits the tools available to law enforcement. While domestic violence cases are always a high priority for departments, expanding the arrest window will improve justice for victims. Recent legislation, while well-intended, has had dire unintended consequences to hold perpetrators accountable. Domestic violence felonies should not be a probational offense. Releasing a DV perpetrator increases the fatality risk significantly for a victim. In a state that consistently is ranking on an average of the top 7 for murdered intimate partners, we cannot afford this misstep in our criminal justice system. Thank you for standing up for domestic violence victims in Nevada and working to make our criminal justice system trauma-informed and victim-centered. Thank you very much.
Thank you.
Good morning, Chair and members of the committee. For the record, my name is Tess Opferman. I am here on behalf of the Nevada Women's Lobby. I'll keep my comments brief because I know you've heard some excellent testimony. I do want to reiterate, we know that the most dangerous time for a victim survivor of domestic violence is when they decide to leave the relationship. After an altercation, an abuser may flee the scene and return at a later time, sometimes even a few days later. The current 24-hour period is simply not long enough for law enforcement to be able to locate an alleged perpetrator. We support any measures to help hold a perpetrator accountable and establish a safer outcome for victim survivors. We feel this bill can directly save lives, and we urge your support. Thank you very much.
Thank you. Is there anyone else here in Carson City? And then we will take these 3, and then we will go down to Las Vegas.
Adrian Hunt, for the record, with Las Vegas Metropolitan Police Department. We support this bill, and we'd love to inform the chair and the committee that we also play a huge component of facilitating victims with the Safe Net advocates. They provide services to the victims as well. Officers are also remove themselves from the advocate and the victim for privacy. We also remain at the scene until the advocate is done. So we definitely wanted to let you guys know that as well, the committee and the chair. If PC is established, of course, officers try to apprehend the subject within 24 hours, and resources and follow-up services support is also offered as well. So that's one of the things that we do when we do come back within that 24 hours. We offer resources and support to the victim as well. So we are in full support. Thank you.
Good morning, Chair. Good morning, members of the committee. Jason Walker, Washoe County Sheriff's Office, testifying in support of AB 51.
Good morning, Chair. Greg Herrera, R&R Partners representing Nevada State Sheriff and Chiefs. It's GREG, Herrera's HERRERA, and Nevada State Sheriff and Chiefs are in full support as well of AB 51. Thank you.
Thank you. We will, if there's anyone else here in Carson City that would like to testify in support, please approach. We're just going to move down to Las Vegas and give them an opportunity right now. So I see we have some in Las Vegas. Please proceed when you're ready.
Hi, Liz Ortenberger, LIZORTENBERGER. I'm the CEO for SafeNest. We work with 25,000 clients a year, and primarily in domestic violence, sexual violence, and trafficking. In 2021, we partnered with UNLV for a study on what survivors want from the justice system. And overwhelmingly, we heard two things: the abuse to stop, and for them to be believed by the justice system. AB 51 creates a pathway. As Nicole Riley shared, we are on average the 7th most dangerous place in the country for women being murdered by men. And while it's not tracked, we believe up to 95% of victims recant or no-show when they are subpoenaed on a warrant, when they are to come and testify within criminal court for their case. We have 2 advocates at the DA's office here in Clark County, and what I can tell you is it's taking up to a year for warrants. We had a client just the other day, had her baby in her arms while she was abused. It took a year for a warrant to be issued in that case. This is absolutely critical that we create this system for survivors to feel like the justice system is working for them, and that is not what we currently have, despite everyone's best efforts in the system. Let's start creating this pathway together. AB 51 is an important first step. And thank you, Officer Hunt, for the shout out to our SafeNest advocates that respond alongside Metro on scene of these critical calls.
Good morning, Chair Miller and members of the committee.
I turned mine off. Do you want to use mine?
Our little musical chairs here. My name is Mark Schifalaqua, SCHIFALACQA. I am the Chief Prosecutor for the City of Henderson. My office handles about 1,000 cases of misdemeanor domestic violence every year. We are here in support of Assembly Bill 51, grateful for the Attorney General as well as the leadership of the district on this bill. The extended time frame will lead to increased victim and public safety. I'm also very supportive of the clarification in Section 16. As you know, the City of Henderson and myself proposed Assembly Bill 42. I was before this body last session, and that was the domestic battery jury trial bill. Because that was such a monumental change in the structure of the domestic violence law, some sections got moved around and there were some grammatical things going on. As you know, it was such a huge change. So there was some unfortunate and inadvertent interpretation that's come for that. So Section 16 will just clarify that felony would be non-probationable, frankly, as it's always been since our. But we are supportive, and thank you so much for your time.
Thank you for that. Is there anyone else there in Las Vegas that would like to support it, testify in support? Okay, thank you. Thank you so much. Is there anyone else here in Carson City that would like to testify in support? Okay, broadcasting, please open the lines for anyone that would like to testify in support of Assembly Bill 51.
Callers, if you would like to testify in support of Assembly Bill 51, please press star 9 now to take your place in the queue. Caller, you are unmuted and may begin.
Good morning, Madam Chair and members of the committee. My name is Jesse Watts, Jessewatts, and I serve as the Sheriff of Eureka County, Nevada. Thank you for your time this morning in hearing my testimony in support of AB 51. I apologize I was not able to make it in person, but Jack Frost had a different idea for my travel plans today. I'm proud to testify in support of AB 51 because this bill is the right thing to do for the victims of domestic violence in our state. Domestic violence is one of the most personal violent crimes in America, but especially in Nevada. Domestic violence spreads from boyfriend-girlfriend, marriages, and family relationships. Incidents of domestic violence do not spare anyone. No race, age, sexual orientation, or individual is exempt from becoming the victim of domestic violence. As a law enforcement officer, I've personally responded to hundreds of domestic violence investigations ranging from domestic battery all the way up to domestic homicide. In several of the domestic battery situations, the suspect has fled before law enforcement's arrival. One example is December 17, 2014. I arrived to find a mother and 3 very small children weeping as the mother had been badly beaten and required to be transported by EMS. The suspect was in the wind. 2 days later, I had contact with the suspect as he was packing his stuff to go to California, where he knew he would not be arrested for the misdemeanor domestic violence warrant. The warrant for this person was issued January 27, 2015, over a month later. The suspect, still to this day, has not been arrested on this warrant, and it's been over 8 years. If this bill was in law at the time, I could have brought this suspect into custody and when I had contact with him outside the 24 hours, but within the proposed 7 days. Another incident was September 23, 2021, when a victim reported domestic violence in 2 different counties as they were traveling on the interstate when the abuse happened. I was not able to locate the suspect as he fled prior to my arrival. I did have contact with the suspect outside the 24 hours, but within the proposed 7 days. I filed my report with the district attorney for charges, and the warrant was not issued until November 16, 2022, over a year later. These are just 2 examples that I've personally experienced to where this bill would have benefited the victims of domestic violence by safeguarding them, ensuring justice was served within a timely manner, and the suspects were held accountable. Due to the 24-hour time constraints, these 2 victims of domestic violence were left abandoned by our system for years. To the committee member's question about warrant arrest versus probable cause arrest, we would simply... Yes, ma'am.
We're a little past the 2 minutes, so can you just conclude your remarks, please?
Yes, I will. I am proud to stand with the Nevada District Attorneys Association and the Attorney General's Office in support of this bill. And ladies and gentlemen of the Judiciary Committee, I ask you to support AB 51 as the victims of domestic violence in the state of Nevada deserve it. I appreciate your time. Thank you, Madam Chair and committee members.
Thank you, Sheriff. Next caller.
Chair, there are no other callers choosing to testify in support at this time.
Thank you. With that, I will open it up to anyone wishing to testify in opposition of Assembly Bill 51. Is there anyone here in Carson City? Not seeing anyone? Anyone in Las Vegas? Broadcasting, is there anyone on the line that would like to testify in opposition?
Callers, if you would like to testify in opposition to Assembly Bill 51, please press star 9 now to take your place in the queue. Chair, there are no other callers choosing to testify at this time.
Thank you for that. Then I will open it up for testimony in neutral. If there's anyone here in Carson City that would like to testify in neutral. Not seeing anyone approach, is there anyone there in Las Vegas that would like to testify in neutral? Also not seeing anyone approach. Broadcasting, is there anyone on the line that would like to testify in neutral?
Callers, if you would like to testify in neutral for Assembly Bill 51, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you so much for that. Not seeing anyone testifying neutral, I will close testimony, and the bill presenters have already indicated that they do not wish to come back up and make final remarks. So with that, I will go ahead and close the hearing on Assembly Bill 51. Our final item today on the agenda is public comment. So again, our phone number is 1-669-900-6833, and the meeting ID is 898-288-21744. So first, we will begin here in Carson City. Is there anyone here that would like to make public comment? And again, public comment is not to make additional comments on the bill, but for anything that is under, any other topics under the purview of this committee. And so with that, please proceed.
Thank you, Madam Chair. Tanya Brown, Advocates for the Inmates, spelled TONJABROWN. During the Attorney General Ford's presentation covering his office, I would just like to say that he unknowingly, or their office unknowingly, continues to carry out the wrongful convictions. They are not aware at the time of when a person is wrongfully convicted, because what they do is they go through the appeals process. Once it leaves the state, it goes to the federal courts. That's where the AG's office steps in. And at that time, they continue to carry out carry out those orders by the lower courts. But what they don't realize is that the person may have been wrongfully convicted through prosecutorial misconduct, ineffective assistance of counsel, and how eyewitness identifications was so flawed in a case. And so they continue to do it, and usually it's upheld. And so this is actually demonstrated, and I want to show how this is demonstrated, because Nevada has had 20 exonerations, and these exonerations have gone through the appeals process. And so even though they have gotten out, they are alive, they are well, but what about the families who have lost their loved ones? They went through that process too. Newly discovered evidence is being found in cases that would benefit those people who have passed away. And we ask that you do consider it. You know, although they may not be in support of it, but again, their office carried out those wrongful convictions. There was no discussion by the AG's office on that part of what their office does. They talked about the factual innocence, but they don't talk about how it's carried out, how a person who has passed away, or what the justice, or seeking justice for them. But they talk about Nevada, people of Nevada, and justice for those in Nevada. People, family members of the decedents, they want justice. Oh, and may I say one thing? I can answer
Quickly, please, Ms.
I
Brown.
can answer Assemblywoman Hansen's question.
Ms. Brown, can you answer it offline? Because, yeah.
Oh, SB 201, 2011 Ombudsman Bill, passed, not.
Thank you, Ms. Brown. Is there anyone else here in Carson City that would like to provide public comment? Is there anyone in Las Vegas that would like to provide public comment? Broadcasting, is there anyone on the line that would like to provide public comment?
Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, advocate for the inmates in Anderson, ANNEMARIEGRANT. Mistaken eyewitness identifications have contributed to approximately 69% of the more than 375 wrongful convictions in the U.S. with a posthumous exoneration bill. The wrongfully convicted would not have to rely on the unrealistic expectation of ensuring the same agency that perpetrated the injustice makes a sincere, honest attempt at independent fact-finding of the wrongful conviction. I'd like to reference Ray Cronin exoneree's letter. I don't ask you to imagine what those 10 years in prison were like for me. I want you to imagine what they'd be like for you if it were your son or daughter serving time for a crime they did not commit. At what point would you stop fighting to clear their names? Being deceased should not exclude families from presenting newly discovered evidence, and I implore this committee to consider the amendment. The deceased wrongfully convicted have families who also carry the burden and pain of knowing their loved one is innocent and advocating to exonerate their loved one. When an innocent person dies in prison, the ultimate travesty of justice occurs. The battle for justice may end for the wrongfully convicted, but for their family, they still carry that burden. Thank you.
Thank you, Ms. Grant. Next caller.
Callers, if you have recently joined and would like to provide public comment, please press star 9 now to take your place in the queue. One moment, Chair. Caller, you are unmuted and may begin.
Yes, my name's Aline Carino, ALEENECARRINO, and I was calling in support of the SB 49 with the amendment. I'm asking that all of you be the voice of the deceased that were newly discovered evidence, even though that they're passed away. They should still be exonerated and their name should be cleared. I'm sure that each one of you would feel the same way, that you were wrongfully convicted and served time and then died in jail wrongfully, again, wrongfully convicted. You would want your name to be cleared. And so I hope that you all consider that. Thank you.
Thank you, caller. Next caller.
Chair, the public line is open. There are no other callers to participate at this time.
Okay, thank you so much for that broadcasting. With that, I will go ahead and close public comment. Just to let everyone know, I believe today was our last presentation here in Assembly Judiciary. So starting tomorrow, it's just bills all the way to the finish line. So I will see you all tomorrow bright and early at 8 a.m. This meeting is adjourned.